Hi, everyone. Sorry, we had a brief technical difficulty, but we have resolved it and we are back. And we were just speaking with attorney Chad Van Horn. One of the questions I was asking him about was whether or not in a Chapter 13, if someone's trying to show they have enough monthly income to qualify to make a payment plan payment or a Chapter 13 payment, and they're receiving unemployment that's set to end at a certain point, how does that affect, they're qualifying for a Chapter 13?
Yeah, so with Chapter 13, you have to have regular monthly income. And normally, if you're putting a plan together based on unemployment, obviously the unemployment's going to end. If you were furloughed and you have a day that you're going to come back, that might not be as big of an issue. But if you lost your job, the company closed, or you don't have likely income, that certainly can become an issue. Luckily, the trustees that we work with, the judges that we work with, are understanding we're in a pandemic and they're becoming more flexible where they can. Obviously, if creditors object, they still have to follow the law exactly as it is. But there is more flexibility there. So if you are on unemployment, you're falling behind on your association dues, mortgage, something like that, you still can consider the Chapter 13, but you're going to need to make sure that you're getting a job to maintain those payments moving forward. Also to hopefully overcome the objection if they're saying that you don't have regular monthly income.
So when someone files for bankruptcy, whether it be a Chapter 7 or a Chapter 13, can you kind of explain what they can expect to happen after they file the petition? Sometimes people aren't aware, there's this meeting of creditors where they're going to have to actually appear in front of someone and maybe ask questions.
Yeah, actually, it's to me, it's the best time you can file bankruptcy right now, because you never have to go to a meeting room. You never have to leave your living room, actually. The Southern District and actually the entire state of Florida, you can do everything by electronic signature now, which is actually new. We needed a wet signature before. And the 341 meeting, which is the meeting of creditors, usually creditors don't show up. It's you, your attorney, and a trustee that's going to oversee the case for the government and the creditors that would appear at the meeting. That's done by telephone as well. Now, of course, there's certain frustrations, technology, people talking over, dogs in the background and whatnot. But most of the trustees, again, have been pretty flexible. It can be frustrating, but at least you don't have to take the day off of work, go to a downtown building that you might not be familiar with, sit in a room full of strangers and talk about your financial issues. So it actually is a really good time to file for that reason. And with a Chapter 7, you go to that 341 meeting. With the Chapter 13, you go to the 341 meeting. Your first plan payment will be due then as well. So if you're catching up on a mortgage association, make sure you have it in your budget that you have that payment, or your case will get dismissed right away.
Yes, very important to make sure they have the money ready to go. Actually, that leads into my next question about what are some of the factors someone should look at if they're wondering when is the right time to file bankruptcy? Should they wait until it's last minute and they're about to get a garnishment or a foreclosure or a sale date, or should they do it earlier? What are some factors? I know you can't, but just what are some factors that?
Yes, certainly. And for each person, it's going to be a little different. And I know the two of you have dealt with emergency cases. Those are our favorite cases, right? They come in, I need to file today. My house is for sale tomorrow. Well, do you have your tax returns? I haven't filed taxes in 10 years. And they don't have the necessary documents. So whenever you have any financial issues, if you're falling behind on your payment, if you find yourself borrowing money from family, to make credit card payments, that's the right time to talk to an attorney. Might not be the right time to file, but at least have an expert take a look at your situations and tell you, because it's very fact specific. So I could say something, I can answer this question directly that is right on point for somebody, where it's the exact wrong thing for somebody else. Don't wait until the judgments are coming in or the garnishments. I have so many clients coming in right now that are getting garnished and their bank accounts are being frozen from judgments from 10 years ago. People think that it's off my credit report, they forgot about me. These guys are still monitoring your credit. So when they see you apply for a mortgage, they see you in a better financial position, that's when they pounce. So definitely don't just forget about it. I know that there's a lot of people that are going into default and maybe having judgments entered against them. those judgments are going to last a really long time. I believe it's up to 30 years in Florida that they'll stick around. So don't let them just collect interest. Get it taken care of. Obviously, if there's a garnishment going into place, I have clients that let the garnishment go through and they think, well, it's going to be paid off eventually, but interest is still accruing, fees are still accruing on that. And the creditors don't always do a good job with their accounting. So if they have money coming in, they might just let it keep going until you recognize that they've taken too much. So the right time to consider bankruptcy is whenever you have some of those warning signs that you're going into debt, you can't pay your debt, you need to borrow money. Also, something very important, if you have to make a decision between paying your mortgage, paying your association, paying your rent, paying your electric, or paying your credit cards, pay the mortgage, pay the credit cards. Don't pay the credit cards. I have so many clients that come in, well, that credit card payment was less, so I could afford it. But that credit card is not going to turn off your lights. That credit card is not going to evict you. So make sure that you prioritize. I always tell my clients, make a budget of money coming in, and then prioritize what you have to pay every month. And then when you run out of money, you don't pay anything else at the end. And that's how you have to do it.
I second and third that comment. Second and third.
Yeah, sometimes also we find that the credit card companies are more maybe vicious in their calling our clients and threatening versus the mortgage companies. So they feel like they're getting these phone calls. They don't want to do something wrong. They don't want to not pay. So they kind of, that seems to be, they're getting all these credit card phone calls. So they just say, okay, I'll pay them because they're harassing me more than the mortgage company. But unfortunately, we find that then the mortgage company is the bigger problem because now they may lose their home. So for Beth, Chad was mentioning, garnishment. Can you talk a little bit about the types of garnishment you see for our senior clients?
Of course. So for our senior clients, we see most predominantly bank garnishments and wage garnishments. The difference is with a bank garnishment, a judgment debtor, judgment creditor, such as, a credit card company or someone will get a court judgment against you. They will get a document called a writ, and they'll send that over to your bank. By law, they're not required to give you notice beforehand, because of course, if you knew that they were going to try to get into your bank account, what would you do? You'd probably pull out all your money. So the law allows them to send the writ directly to the bank. And once the bank receives it, by law, they're required to freeze money in your account or in a safety deposit box that has your name associated with that account. There are exemptions to this, but for the most part, banks are required under the law to freeze money. So you have to be careful when it comes to bank garnishments and having judgments entered against you, because that's something that could be looming at any time. The other prevalent garnishment we see are wage garnishments. That same judgment creditor can send a writ of continuing garnishment to your employer and say, listen, we have a judgment against your employee. We want you to freeze up to 25% of their disposable earnings in order to pay us back what they owe. What is disposable earnings? Well, disposable earnings is your gross salary minus legally required deductions. What are legally required deductions? Those are things like Social Security, Medicare, if we had a state tax, federal taxes. That doesn't include money that you're taking out to contribute to a retirement plan. That doesn't include your insurance, your family insurance. So a lot of times people equate their disposable earnings to their net earnings, and it's not always the same thing. And if you can imagine having 25% of your salary being taken away, that's a quarter of what you need to live on. That's a pretty traumatic thing. So wage garnishments are very serious.
Okay. Usually they're getting garnished because there's been a judgment entered against them. Sometimes it stems from a debt, like a credit card debt. So when you see clients that have been served with credit card cases, or someone served with a lawsuit from their credit card company, what do you suggest they do? Because sometimes it seems as though it may just get ignored.
We always suggest that that's the exact opposite of what you do. You never ignore a lawsuit. You never ignore a summons, no matter how stressed you are about it, no matter how much you want it to go away. It's not going to go away by ignoring it. So our number one advice is that if you are served with a lawsuit for an old credit card debt, that you address it immediately. You have a certain amount of days to respond to a lawsuit. You may get notice of what's called a pretrial conference for you to appear in court in order for you to try to work things out with the other side, or for the judge to determine, what do you want to do with the case. You have to appear at pretrial conferences. If you don't, then a judgment can be entered against you just for not appearing. So our advice when you're being sued for any sort of debt is always to, face it, consult an attorney, and move on it quickly. You don't want to ignore that.
And real to that point, I have many clients that come in after they get the judgment entered, and they say, well, I have a statute of limitations defense. I have this, I have that. I say, well, it's too late. The worst time to fight a lawsuit is after you've already lost. Mm-hmm. So and it happens all the time, and bankruptcy courts aren't appellate courts. So I can't go to the bankruptcy court and say, hey, this isn't a real judgment. This was garbage. I mean, only the state court judge can change it, and then the appellate court above that. So that's a very, very good point. Just as soon as you get that, whatever that paper is, take it to an attorney immediately.
Yes. And also, a lot of times you may not get that first notice from the actual credit card company that you had the credit card with. It's been, bought and sold to what we know as a third-party debt buyer. Beth, can you explain that a little bit?
A third-party debt buyer is really just kind of exactly what it sounds like, right? It's a company that makes their money buying debt from original creditors. So let's say you had a credit card with Citibank and you didn't pay Citibank. Citibank may write that debt off as bad debt, but in order to try to recoup some of the money that you didn't pay them back, they'll sell it to another company, ABC, Financial Corp. They'll sell it to them for pennies on the dollar. And then ABC Financial Corp now has the right to sue you as if they were Citibank, as if you owed them this money, because now they're the owner of the debt. And that is exactly what they do. They file thousands of lawsuits a year collecting debt that was issued by another creditor. And really what they're looking for is exactly what we stated. They're looking for you not to respond, to ignore it, to do nothing, because that gives them a judgment and then gives them the opportunity to try to collect on that judgment. So that again goes back to reiterating the point of never ignoring. If you get a lawsuit from a company that you don't know who these people are, you've never had a business relationship with them, don't ignore it, because they may very well be a company that purchased it from someone you did do business with, and they still have the right to collect that money.
So if someone has a question, they're this girl, you're saying I owe this money. I don't recall ever owing this money. I don't know what this debt is about. What are some things they can do to try and understand where this came from or what this debt is, if they truly just can't recall why they're saying they owe $1,200 to this entity?
Well, there's a really important law called the Federal Debt Collection Practices Act. It allows consumers to dispute debts that they don't have knowledge of or that they just need more information of. You can write a letter, a debt dispute letter, to whoever is trying to collect funds from you. And there are lots of resources online for you to obtain. The CFPB, which is the Consumer Financial Protection Bureau, actually has templates on their website. They're a huge regulatory agency that regulates consumer debt and debt collections. They have these types of form letters that you can use to contact a creditor to say, I don't know who you are. You have to validate and prove to me what this debt is about if you want to be able to collect it from me. So consumers who are receiving notices from collections agencies that they don't know about, it's really important that you send out a letter to them demanding that they prove what that debt is in reference to.
Okay, great. We'll post website information to the chat box at the end of this. I also wanted to just for you to follow up on, because I know when Chad was talking about, when we look at our budget and we're trying to figure out who gets paid first, are there any other additional comments you have? Because he was speaking our language, because that's what that's exactly what we tell clients.
Well, what we tell clients is it is about prioritizing debt, especially when with our senior clients who are often collecting some sort of retirement benefit. Their budgets are limited. They don't anticipate that they're going to increase their income in the future. They play the lotto, but who knows? So you have to be able to look at how much you're bringing in and decide who are the most important people that need to be paid. That means you have to make a determination. Is my mortgage more important than paying, these 5 credit cards? Our answer to that is absolutely yes. Your mortgage, where you live, paying your utilities, sometimes paying your car note if that's the car that you need in order to get you to and from, work. Those are, that's secure debt. That means if you don't pay it, someone has the right to come and take something from you in order to be paid. Credit cards are not secure debt. And so sometimes it's unfortunate that we have senior clients that are very traditional. They're very prideful. They take pride in paying what they owe and being able to, not owe anyone anything. But when you get to a certain point where you just don't have enough, it does come down to prioritizing certain debts.
And when you guys do the budget, I always tell people, make sure that you actually have the bank statements with you as well. Because I don't know if you come across this where a client, they'll do a budget from memory and you're like, whoa, you have an extra $1,000 a month. They're like, no, I don't. So then you go through the bank statements and they're like, oh yeah, I didn't realize I was spending that much on this. I didn't realize I was spending that much on that. So very few people actually go through their bank statements and realize what they're spending money on every month.
Very true. We often have our clients, we tell them when we're going to do a budget, we need you to sit down and actually pull all of the bills that you pay. And like you said, bring a bank statement if you need to, so that we can have an accurate reflection of, some people grocery shop twice a month, and some of our clients go to the grocery store every 3 days. That they're not realizing how much that adds up over time.
Chad, when we were talking about, all of a sudden you get this letter from a creditor and you're like, who the heck are they? I don't recall this debt. I'm assuming that happens to clients in bankruptcy when they start getting the claims coming in, and they get claims that they weren't aware of, or, they had no idea or can't recall that they owed this debt. Can you kind of explain what the claims process is when a proof of claim is filed?
Yeah, certainly. So in Chapter 13 specifically, there's a certain period, it's approximately 4 to 5 months, that creditors have to make a claim against the bankruptcy estate. Basically, they're saying they're owed money by you. So they have to provide documentation for it. And obviously we deal with a lot of the debt buyers, because some of these debt buyers are billion-dollar companies that are just buying up for pennies on the dollar. Just because they're buying for pennies on the dollar doesn't mean they'll settle for pennies on the dollar too. A lot of people get that mixed up because a lot of the debt is uncollectible and or discharged in bankruptcy. But what these creditors will do is they'll file what's called a proof of claim. We do a claims review process with our client. If it matches what's on the schedules, it's really not much of an issue. Sometimes we'll get some outliers out there where they'll say they have secured claims on different things that we have to deal with. But it's a relatively smooth process of dealing with claims. And a lot of the times it won't matter that much anyway if they're unsecured claims, because the number that's getting paid to the creditors does not change usually based on the amount of claims. So the other creditors might be upset because it could dilute what they get. But as far as the people that I work, the clients that I work with, they want to know, okay, how much do I have to pay every month? I don't really care if Chase gets it or Amex gets it or Bank of America or Capital One. I don't care who gets the money. Obviously, when it comes to secured creditors, that you care because you want your secured creditors or IRS, which could be priority debt, or student loans, you want to prioritize those. But as far as the unsecureds, it's a pretty smooth process.
And if I could just jump in there about in reference to creditors and their payment plans, usually with third-party debt buyers, they are willing to settle a little bit more. They're more flexible in their settlement than an original creditor. So if you're being sued by a third-party debt buyer before they have a judgment against you, that's actually a better time to really try and get a good settlement, a payment plan that's affordable for you, than waiting until ignoring it and a judgment is entered, because once they have their judgment, there's no incentive for them to settle with you at that point. So just from a realistic standpoint, working these things out before a judgment is entered is always preferable, and it keeps you in a stronger negotiating position.
Yeah, I agree 100%. That's why, as you both have said, you know, addressing these issues early, as soon as you get that first letter, you know, trying to figure out what your plan is. Maybe that's not the day you go file bankruptcy, but maybe that's the day you go see what your options are, what you can do. And if plan A doesn't work, you have plan B, you have plan C. And as Chad said, once you've lost the lawsuit, it's harder for an attorney to then turn back time and try and get something resolved. So those are really great suggestions. Chad, I had a question for you. What are some just like common pitfalls or mistakes you see people make when they're trying to do a bankruptcy or they're in a bankruptcy? Things they think might help but don't help, or?
Yeah, so there's a bunch of them, especially now. We're seeing more pro se, more people that think they can do it on their own. And I always tell clients, you know, bankruptcy is really easy when everything goes well. But whenever it doesn't go well, that's when you really need an expert to be able to step in and try to fix everything. So the number one issue that I see is the bankruptcy schedules. There's a lot of questions that you have to fill out. And some of them are very straightforward, like, do you own real estate? Yes or no, right? That's pretty straightforward. And then some are not as straightforward as far as, especially with the statement of financial affairs. And if you don't answer those questions accurately, the trustee, the judge, can assume that you're lying. And then once they assume you're lying, then they can revoke your discharge and go through that process. And then once your discharge is revoked, you're basically stuck with that debt for life. You can never, unless you settle the debt, unless you negotiate and settle the debt, you can never get a discharge of that debt. So the number one mistake I see is, you know, clients go and they say, oh, bankruptcy is easy. I just fill out these documents and file it. And filing and hoping is really not a plan. And then when they come into my office and like everything's a mess, I try to clean it up, but the other side, the creditors or whoever else is out there that's objecting, always can go back to, but you lied day one when you filed it. And there's case law out there that even if you forgot to list, you know, a company that you owned years ago that didn't do anything, that could be grounds for denying your discharge. And the number one place I see this is when there's exes involved, ex-spouses, ex-business partners, you know, people with an axe to grind, really. You don't see the large creditors like, you know, Capital One, Bank of America, coming in that aggressively, unless there was fraud. Obviously, if there was fraud, that's a different thing. But you always see somebody with that personal relationship that wants to come in and blow a case up. So really work with somebody that knows what they're doing, that has been through the process, and they'll help you avoid pitfalls like forgetting to put something on the schedules that it's hard to say, well, I put it on there now. Well, you already lied once. So what else didn't you put on here? And then they start doing home inspections and all these other things. And it becomes a much bigger deal than if you would have just done it right from the beginning.
Very, very good tip there. Because, you know, I've sat in bankruptcy court before. I've sat in the meeting of creditors when, you know, you see someone up there and things maybe start to go south a little bit, and it's not, you know, they start mentioning bank accounts and they don't, and you just see that it's not going to end well, and that it starts to unravel a bit. So I completely agree with you on that. But Beth, because we have a lot of, you know, senior clients that are receiving, you know, Social Security, and I think there's a lot of, you know, different misconceptions about, well, they can't take my, you know, creditors can't take my Social Security. And there are certain protections, correct, for Social Security?
Absolutely. Federal law allows that Social Security benefits are exempt from garnishment. There is even a special provision for bank garnishments where Social Security have what's called an automatic protection. What that means is when a judgment creditor sends a writ over to a bank, the bank is required under law to review your account for the past 60 days to determine if any federal benefits were deposited into your account. That would be Social Security, certain federal pensions, your VA benefits. If any of that was deposited into your account over the last 60 days, then the bank has to add all that benefits amount together as a total, and that's what's called your automatic protection limit. They can't garnish anything in your account as long as your balance is under that limit. Well, what does that mean? If, you know, by some crazy happenstance, and this doesn't happen very often, but let's say our client came into a lump sum of money and they've kind of been living on that money and they haven't been spending their Social Security. So maybe they have 4 months of Social Security in the account and not 2 months. Well, that automatic protection limit is only going to protect that 2-month amount. The rest of it is going to be frozen, but the law still says that you would be entitled to get that back. Unfortunately, you just have to go to court to get it. But as long as you can prove that the funds in the account stem from or originate from an exempt source such as federal benefits, you will be entitled to receive those funds back.
Okay, thank you. And then Chad and Barbeth, I know like this next issue is both one that you both see. We see often a lot of it is student loan issues, and for our seniors, a lot of times it's a situation where they may be a co-signer. They sign for a grandchild. Chad, can you explain a little bit about the difference, the main differences between the private and the federal student loans?
Certainly. So private and federal student loans are very, very different. And there's different ways that you can handle, there's different resolutions to both of them. So the private student loans, it's just like any other loan that you would get, except it's worse because it cannot be discharged in bankruptcy like a credit card without going through a proceeding called an adversary proceeding and hitting an undue hardship standard, which generally speaking has been high. We're chipping away at it. And obviously it's a big issue that maybe Congress will act or do something here in the future. Maybe they won't. But with the private student loans, if you're unable to pay the private student loans, you can actually renegotiate terms and do debt negotiation like you could with a credit card. With the federal student loans, you actually have less options as far as negotiating with them, because under the Higher Education Act, there's only certain things they can do. And it's not really going to be a negotiation where, hey, I'll give you 50% over 5 years. It's whether you're going to fit in one of their programs, and they have, you know, standard repayment, extended repayment, income-driven repayment. The good thing about the federal student loans, if your income is below a certain amount and you give them your income information, your payment could be zero. So you are getting a qualified payment every month with the federal student loans, and after 10 years, 20 years, or 25 years, depending on where you work, you will qualify for loan forgiveness eventually. Also, if you are older and you pass away with these federal student loans, they go away as well. They don't collect from your estate. So the federal student loans, I know everybody talks about student loans being a huge issue. Obviously, you don't want to have a ton of debt outstanding, but with the federal student loan options, they are workable. You just got to make sure that you're in the right program and following up with those.
And just to chime in for our senior clients, it's really important, as Chad has said, to do what you can with them before they go into defaults. Try to work out an income-based repayment or something like that. Unfortunately, we see senior clients who co-sign these loans for grandkids or children. The senior doesn't think about it, and then later on, when the grandchild or the child stops paying the student loan, now we're seeing seniors coming in with what's called an administrative wage garnishment. Their Social Security is actually being garnished because federal student loans are of the very small category of debts that actually can be garnished from your Social Security. So you have all these, creditors that can't touch your Social Security. Guess what? The federal government isn't one of them. So your Social Security can actually be garnished up to 15% of your income, as long as it doesn't bring your Social Security monthly benefit below $750. So that could be a substantial amount of money for seniors who are just living on, $1,100, $1,200 a month or something like that. So it's really important that you know if you have student loans, in your name, whether you're the primary borrower or you're a co-borrower, that as a senior, you don't co-sign. As much as you want to help your kids and your grandkids, maybe it's better for you to just, if you want to give them a lump sum gift or something, but do not sign student loans for anyone else, because as Chad has stated, federal loans don't go away and they haunt you for a really long time. It's really difficult to get around student loan defaults, especially for our seniors. Usually, in very few cases, we've seen seniors who qualified for a disability waiver of their Social Security garnishment, but that's a really high standard. It requires you to prove that you are permanently and totally disabled and cannot afford to pay this amount. There are certain little programs out there for vets as well, but really there's not a lot of options once you've defaulted on a federal student loan payment and they start garnishing your Social Security. So you have to be really, really careful about that.
Thank you, Barbeth and Chad, for your insight on that issue of student loans. It is something we see, and they are, they can be difficult to deal with, but there are some options. So again, it's something that if you're struggling with, it's best to, see what you can do to manage to get that debt repaid. So we lost a little bit of our intro due to technical issues, but I just wanted, because, this is based around, what's happening now with consumers and COVID-19. And as we discussed earlier, since March, so many people have lost their jobs. Maybe they've had to rely on unemployment. They've fallen behind on their mortgages. And one of the things that came through in the CARES Act, and that other lenders were doing as well, is this, forbearance type program. And so I know we probably all share the same thought that, it could be okay, but you have to truly understand what a forbearance is, before you decide to accept it, because a lot of people don't quite understand that it's not necessarily, or it's not at all a forgiveness of debt, but it's a delay of payment. So, Chad, could you just talk a little bit about, what's your take on the forbearance programs out there?
Yeah, so the first time that I saw this was during the last hurricane last year, that they came up with these brilliant programs where you get a certain period of time that you don't have to make your monthly payment, but at the end of the time, you have to make up all the payments at that time. So why wouldn't I just make my payment then? If I was able to save money every month in the amount of my payment, I would just make my payment. This time it's a little different from what I'm seeing. Although legally speaking, they're not obligated to offer modifications or put it on the back of the loan based on the documentation that I've seen. So I am a little nervous because I don't trust the lenders. I don't trust the mortgage industry in general, that they're going to cherry pick the loans that they like. And they're going to say, okay, yeah, we'll work with you, but we're not going to work with you. And they're going to default people that, for whatever reason, they don't want that loan on their books anymore, and the people that they want to work with, they'll figure out ways to modify. So what I'm telling my clients is you have to stay in constant communication with the lender. You almost have to be annoying. Like you just have to follow up with them over and over again with, okay, how are we going to work this out? How are we going to, my deferment or forbearance runs out in 30 days, runs out in 29 days. Like, what are we doing? Because the worst thing that could happen is you get caught in that foreclosure trap, and then they start adding all these different fees on, and you get forced place insurance. You get all these different, and you're like, I just accepted a 90-day forbearance, and where did I end up? So you just got to be really careful with that. If you don't need the forbearance, don't take it. And I think that's the easiest way to deal with it. Just make sure that you're making your payment every time. If you do need the forbearance, obviously take it and extend it as long as you need so that you don't default. But get on top of it as far as getting back into payment and getting back into good standing with them, because the longer it goes, the homeowner always loses. It's never a benefit to the homeowner in the long term. So don't live off your equity. Obviously, it'd be great, especially in Florida, if you can get your homestead paid off and have that exempt asset where at least if everything else goes wrong, you'll have your house at the end of the day. So that's my 2 cents on that.
I'd just like to jump in and echo what Chad is saying about staying in constant communication with your lender, with your servicer. You have to remember that they are literally thinking about and servicing thousands of loans. You only have to think about your loan. So when we're talking about who is going to prioritize what's happening with your mortgage, absolutely the answer is going to be you. So that's really, really imperative. It's also imperative for you to understand whether you have a federally backed mortgage or not. Allow all of the protections and the benefits and the programs that are out there are for federally backed mortgages. So that needs to be a question that you're asking your lender, because you may be able to get a forbearance without a federally backed mortgage, but you're not going to get the additional protections that are afforded those mortgages. Federally backed mortgages have, as Chad is stating, have or a higher likelihood of being able to get a modification. They have programs where FHA is going to be able to step in and assist with some of your delinquent payments, but those are only for very particular mortgage products. So don't allow your servicer to put you into a forbearance, not understanding whether you're going to have access to those programs at the end of your forbearance, because that's exactly what a forbearance is. It's just a delay on your payment. They are going to expect that lump sum at the end unless you know what options that you have to work out that balance at the end of the forbearance.
Thank you both for that, because that's something I just see a lot of, a misunderstanding. People don't, they said, oh, well, they told me, it just goes away, or, and unfortunately by then, once someone's multiple months behind in their mortgage, playing catch up isn't always necessarily doable. And they may be, forced into thinking about, having to do a bankruptcy to save their home, whereas before, maybe that wouldn't have been something they needed to do. So as we wrap up, Chad, if you would just quickly re-explain the differences between the consumer bankruptcy of Chapter 7 and Chapter 13, because we're not sure that made it to the beginning, may have gotten chopped off, and it's such an important concept for people to understand.
Yeah, certainly. So I hope I remember. Let me scroll up and look at my notes again. So, and something playing off of what you just said as well. I'm one of the few bankruptcy attorneys where and I think actually maybe more do than I know. I really try to keep people out of bankruptcy if I can. I think bankruptcy, it's great to have that option, because without that option, the creditors would have all the power. So, but it still is better if you can work something out. If you only have an issue with your mortgage company, you should be able to work it out with your mortgage company without going into Chapter 13. Because the mortgage company knows you can go into Chapter 13 and they know what that would look like. And that's just going to increase, because you're going to have trustee fees, attorney's fees, everything on top of that. So I really try to make sure that my clients are spending the least amount they have to get the result that they need. So going back into Chapter 7 versus 13, Chapter 7 is the liquidation, generally speaking, for people that have unsecured debt and don't have a ton of assets. they're below the median income. There's ways around the median income. I won't go into too much detail on that. But one example is if you have primarily business debt, you can waive the CMI. So Chapter 7 is that traditional bankruptcy. You're done in about 3 to 4 months. You receive your discharge. It takes about 12 to 18 months to get your credit back to a place where you can qualify for a mortgage again and start getting better rates. Chapter 13 is generally used if you have assets, if you're above median income, or if you're trying to save your home. That's why Chapter 13 was designed in the first place. If you default on your mortgage, default with an association or somebody else that can either foreclose or take your car, you're able to get caught up over a 3 to 5 year payment plan. Also, you can get rid of a lot of the unsecured debt. Generally speaking, your unsecured creditors will get paid a small percentage of what's owed. So you're really going to want to run. It's good to do your research, but whenever you're meeting with an attorney, whether bankruptcy attorney or anything, have your questions ready, but come with an open mind. I remember I lost out on a client once because they wanted to file a Chapter 10, and I couldn't convince them that there was no Chapter 10, even after showing them the bankruptcy code. They said, well, you didn't get the new one. I said, oh, okay. So just come with an open mind and find an attorney that you're going to trust. Trust but verify. Ask questions. Make sure they're there. But there's a lot of good attorneys out there that are really working hard for people. So find somebody that you like and that you can trust. Because if you're not going to trust the attorney, it's not going to be a good relationship. So.
Okay, thank you for those tips and for re-explaining the different types of consumer bankruptcy. Hopefully now we are all better equipped to know what options are out there. Barbeth, did you have any final thoughts on some final thoughts for consumers out there that may be facing debt due to COVID-19?
I really just think, if you don't take anything away from tonight's presentation other than this, that it being proactive, not hiding, not sticking your head in the sand, not ignoring the issues, but being proactive, speaking with your creditors. It's much easier to work out something before a judgment is entered, or before you have to end up in bankruptcy court, or you're forced to end up in bankruptcy court, than it is for you to have to deal with these things on the back end. So that's probably my number one advice about debt and dealing with debt, is being proactive.
All right, thank you. So that's it for this presentation.
I'll hop back in, Sarah. I was in the initial video, but with everything that went on, that video disappeared. So thank you all, Sarah, Chad, and Barbeth, for kind of doing a restart for us and getting the information out there, because in this time it really is very important. Again, Sarah, thank you for hosting. You're our supervising attorney for our senior law unit at Coast to Coast, and Barbeth, an attorney in our senior law unit who is just phenomenal and does so many different things in the unit as well. And then Chad Van Horn, who donated his time tonight pro bono, and is always very giving of his time to our staff and for clients here in Broward County with Van Horn Law Group. So thank you, Chad, as always, for that. I will do the quick reminder, because it got cut off from the beginning one, is that the information that was provided tonight was legal information and not legal advice. And it is accurate as of the time of this airing, which is September the 24th, 2020. So just keep that in mind. And for everyone that watched, thank you for doing so. Please be sure to follow us on Facebook at Coast to Coast Legal Aid, or you can check us out on YouTube, same, at Coast to Coast Legal Aid. And you'll see all the videos that we host here as part of our virtual clinic series. So thank you all again, Chad, Sarah, and Barbeth, and for everyone that watched tonight. Good night.
Thank you.
Good night.
Yeah.